Welcome to the Information Management 360 podcast, brought to you by Archive 360, the industry experts in information management for the digital age. The Information Management 360 podcast delivers thoughtful conversations about compliance, records management, data security, e-discovery, and much more, so you can learn how to better manage and protect your data in the cloud. So let's get started.
Welcome to the Archive 360 podcast titled Privacy Impact Assessments, the GDPR, and the Fall of the Privacy Shield. With me again today for this podcast is Jim McCarthy, Chief Compliance Officer and General Counsel for Archive 360. My name is Bill Tolson, and I am the VP of Compliance and e-Discovery at Archive 360. You know, with the invalidation of the EU-US Privacy Shield in July, many U.S. companies are wondering if they will ever be able to take possession of EU personal information again. Now, with the current regulatory environment around EU data privacy concerns, companies will need to adopt processes and technologies that put more direct control of the data in their hands when storing and utilizing data in cloud solutions. In this podcast, Jim and I will explore the issues that caused the Court of Justice of the European Union to invalidate the Privacy Shield, and additionally, what U.S. companies can do to address the issues to get the data flowing again. You know, there are two potential tools to address this PI data transfer roadblock. And they are, number one, using local on-premise encryption and key storage to ensure cloud service providers cannot independently decrypt and access your company's data, including for government subpoenas. And number two, proactively putting in place a third-party privacy impact assessment to demonstrate to the EU GDPR authorities that the US-based company has taken the needed additional security steps to better protect the EU PI. So with that in mind, the invalidation of the Privacy Shield came here recently from what's known as the Schrems II decision. So Jim, can you explain the main issues that the CJEU had around the Privacy Shield and why EU and U.S. companies scrambling to figure out if the issues can be addressed?
Sure, and it's good to be with you today, Bill. Let's put this into context. What are we talking about? We speak to data transfers to the United States. What is that? What does it apply to? And I like to think about it like this. Very simply stated, it's any data about an EU citizen that's maintained in any EU's company's computers that's shared with a U.S. company. It's simply that broad. Put some examples to get a clearer idea. An insurance broker in England reduces claim notes to its computer CRM system and then shares that information with its own U.S. parent. This is what we call a restricted transfer that's subject to this new law. A German bank shares its own customers' data, its accounts with its U.S. affiliate, a restricted transfer. And there's also not only these overt things, Bill, but we're also talking about benign applications. Let's say that there's a localized business in the EU that doesn't need to share its data to operate its business. Let's say a hotel. But let's say that same hotel uses a cloud IT service for bookings, like one of the popular sites, TripAdvisor, Kayak, etc., and they store or process the hotel's data outside the EU. Another restricted transfer. So when we start to look at all the different applications, we start to get an idea how big and how much ground this covers. And I think it's best stated by our own U.S. Secretary of Commerce, Wilbur Ross. As soon as the Schrems II decision came out, he identified that this was really about a $7 trillion transatlantic economic relationship that affects more than 5,300 companies. So that's what we're talking about, Bill. That's what's on the line. And it's good to have that context when we're talking about the issue. And the issue in the Schrems 2 was about what we now refer to as the U.S. Privacy Shield. And these are simply a structure that's built to assure these EU regulators that the protections that United States has over personal data is not compromised. And in that, compromised by even United States law enforcement and investigation of those people's records. So that's the background. That's the issue that we're talking about in this decision.
Yeah, the Schrems 2 was really interesting in that it, number one, invalidated the privacy shield and put everybody, questioning, how are we going to transfer data? Because there is a lot of data transfer from the EU to the US for all kinds of economic reasons, as well as many others. But, interestingly, I think right before, within a half a year of this case, being decided, but the U.S. passed the Cloud Act, which basically gave the U.S. government, as well as I think the U.S. courts, the ability to ask for data held by U.S. companies, no matter where that data was held, to ask for it to be presented to them for intelligence reasons or e-discovery or whatever it happened to be. And because of that, the Cloud Act being put into law, the EU saw that as, on their side, massive government overreach, and that EU personal information was no longer, protectable under the Privacy Shield, because the Privacy Shield had nothing to do with the legal, capabilities of, the government agencies as well as the court system. So, and reading the decision and the notes around it, the fact that the U.S. government or court system can demand information, even PI, from EU custodians, if it's held by U.S. companies, really, I think, was one of the underlying decisions for why the court invalidated the Privacy Shield. Is that correct?
It is, and I think it's important to step back for a moment. The Privacy Shield litigation that we call Schrems 2, some background on that may be important, is that Schrems 2, as the name may imply, originated from the predecessor case that we call Schrems 1, which was the initial litigation that invalidated what was known as the safe harbor provision of U.S. law. And that the Privacy Shield that we're talking about in Schrems 2 is simply the successor mechanism that was created hastily once the Schrems 1 decision was made in 2015. So, it's 5 years later, but we're still really just finding out what the scope of these decisions mean for transatlantic commerce.
Yeah, and that's really the basis, the main discussion point for this podcast is, now that Privacy Shield has been invalidated, looking at GDPR, for example, GDPR has an article in it that stipulates what they call data protection impact assessments, which is basically a privacy impact assessment. How can the data collector, the EU company passing data to a U.S. processor, how can they ensure that PI is not going to be, basically pulled into a intelligence agency net or into an e-discovery without the owner of the data, having some say about it. With the Privacy Shield gone away in that specific Schrems 2 case, they referred back to something that's called standard contractual clauses as the fallback, tool. But that same decision also called into question the viability of relying on SEC's standard contractual clauses in the future because they don't do exactly what the Privacy Shield didn't do as well, and that's protect EU PI from government access. So that decision that the court basically put into play the possibility that standard contractual clauses will be invalidated shortly because, again, they don't address the main issue. In fact, I've seen in some of the articles that Schrems is already positioning for a third lawsuit going directly after SECs.
It stands to reason, right, Bill? I mean, the first mechanism that we set up was under fire in Schrems 1. That was the safe harbor. The second is the privacy shield. Stands to reason that the next artificial construct that they build, which doesn't address the central issue, like you say, is going to be next as far as litigation. And you could say that the result of the second Schrems was arguably worse than that in the first. Not only did the invalidation of the transatlantic transfer program was challenged successfully, but it destabilized the main alternative transfer message. So I think now you have a situation where the CGEU, that's the judicial branch of the EU, is now establishing its own sort of primacy on the subject matter, rather than looking at the individual states that are impacted. So I think you are right. I think we will set the stage shortly for Schrems 3. And if anyone's interested in where we're getting this name from, who is Schrems? We've addressed it in prior podcasts, Bill, but I always thought it was interesting to note that Max Schrems was a Austrian law student that initially complained to the Irish Data Protection Commissioner that his Facebook account, which, Facebook was headquartered, European headquarters in Ireland, could actually be obtained by U.S. authorities. And after the Edward Snowden disclosures in 2013, he became sort of a privacy activist. And so it's Max Schrems we have to thank for the name here, Bill. But it certainly moved beyond Facebook.
Yeah, and speaking about Facebook, it's really interesting. A month ago, almost exactly, an EU privacy regulator sent Facebook a preliminary order to suspend data transfers to the U.S., in reality to itself in the U.S., about its EU users. Basically, it's an operational and legal challenge, for Facebook and other tech giants. And the order to stop stop doing data transfers is really based off of number one, the privacy shield going down, and then this question around SECs. But the EU privacy regulator in this case, I think, was Ireland, and saying to suspend the data transfer suggests that it has also found standard contractual clauses aren't sufficient under the Max 2 or the Schrems 2 ruling. In that, if that logic stands, then SCCs might probably will be ruled invalid for other large technology and telecommunications companies that fall under the purview of the U.S. surveillance laws discussed in the EU court ruling, including under the Foreign Intelligence Surveillance Act, Section 702. But very quickly back on Max Schrems. The guy has really made a name for himself, and if he is now a practicing attorney, I would suggest that his billable rate is probably pretty high.
Certainly, he's got some notoriety on it. Bill, one other part of the ruling that the CJ EU had in July was that they found that the ombudsman that act as the safety valve for examining whether or not personal data is transferred to the U.S. in violation of the rule. Now, they found fault with that ombudsman, and that should be concerning to people who still rely on standard contractual clauses, because arguably that's what we put into place now, is that sort of evaluation as to whether or not the particular transfers in question are problematic. So I think that it would be difficult to rely on the standard contractual clauses as a long-term plan.
Yeah, I agree, and I think lots of people agree on that. And in the face of Facebook being told to not send data to the U.S. based on the current tools, I think 2 weeks ago, Facebook put a comment out on a press release saying if this ruling holds, meaning Facebook stopped sending stuff and stop sending data to yourself in the U.S., then Facebook stated that we cannot do business in the EU anymore if that's the case. So, I mean, this is obviously going up the ladder of priority for both the governments over there as well as the big tech companies here. And depending on how these things are decided, what could big tech, Facebook, and the rest of them do in sending information back and forth? I mean, it really puts a question mark there, and Facebook really kind of set the stage to say we can't do business this way. So there's a real possibility that we're going to have to turn off Facebook in the EU. Now, do I think that's going to happen? Probably not. But that really brings up the issue or the question of, if the biggest issue the EU has with U.S. laws is the ability for the courts or government agencies to legally get access to all data held by U.S. companies, obviously with the proper court rulings, is there anything that U.S. companies can do to put in place that would help them conform with or address the issues that the EU court had, but allow them to continue to move data across? And again, in my mind, and we haven't mentioned this yet in this podcast, but one of the biggest issues that I think that the EU has is, number one, the government getting access, demanding access to the data legally, obviously, but also nowadays with all of the data, or most companies storing their data in the cloud, the ability for U.S. agencies or the courts to go to a cloud provider and demand that cloud provider, number one, decrypt their client's data and hand it over to them. And oh, by the way, it's a secrecy warrant, so you cannot tell the data owner that we actually did this. And that's when I talk to customers and potential clients and stuff, that's one of the biggest problems they have is that this data, which positions them as potentially being out of regulatory compliance with the GDPR, and we all know the size of the fines there can be huge, but then the data being copied without them ever knowing it really sets CISOs on edge. That's for sure.
Sure, and let's look at it from the other side. The purpose behind these things, these gag orders, if you will, that restrict the ISP from disclosing that to their customer is clear. I mean, law enforcement does not want to tip off the subjects to whom they're investigating that they're being investigated.
Sure. So and it's hard to argue with that.
Yeah, we want robust law enforcement techniques, and we have this struggle now. How do we deal with businesses in a relatively flat and smaller world that geographical boundaries don't make sense anymore? That's what we're up against. And so let's circle back to your question. What options do companies have? Because this is the current situation. There are conflicts of laws that these companies that have transatlantic relationships, commercial relationships, simply cannot satisfy both ends. What do they do?
Yeah, I mean, I don't think the issue is completely addressable, but I think parts of it are. And we've talked about this, and the idea that number one, a data processor in the United States, somebody taking possession of EU PI, they're now, with these rulings and with worries from before, they're somewhat hesitant to put this data in the cloud because they don't want a court or a government agency going to their cloud provider and getting getting the data without them knowing about it. And the issue is, can that be stopped or slowed down, but mostly stopped because it's in the cloud and there's a third party actually controlling it? The only obvious way to stop it is to store everything on-prem. Don't put it up in the cloud. Therefore, if a government agency wants the data, they have to get, the legal authority to do it and then come directly to you, the data owner, and then you can choose to fight it in court and all kinds of neat stuff. But if it's in a third-party cloud, it's you may never know that data's ever been accessed. So the question is, are there policies, procedures, and technologies that could at least address some of those? And one of the obvious ones is, if you're going to put it in the cloud, encrypt it, and don't rely on the cloud provider to encrypt the data. Encrypt it yourself on-prem before you store it in the cloud. Then an entity can come to the cloud provider and say, give me the data and decrypt it. And what's going to happen? The cloud provider is going to say, sure, I'll make a copy of it for you, but it's fully encrypted. I don't have the encryption keys. Therefore, that at least one issue is sort of addressed. So this idea of encrypting, especially this type of data, but any kind of data that you're going to move into a third-party cloud repository, encrypt it on-prem and then move it up to the clouds and keep your encryption keys on-premise. Therefore, you control who actually has access to it, not the third-party cloud provider.
Yeah, I want to stop you there, Bill, because candidly, of all the options that are out there, that's the one I'd like to focus on, because, and let's circle back to encrypting it before it leaves the house. What other options could be available? I mean, one could be data localization, where businesses simply retain all of their data within their own jurisdiction. It's hard to imagine how many companies that work from country to country could carry out their business if data that originates within the EU can't come out of it. So, these are the practical difficulties of this decision. The other option, which is not at all comforting either, is do nothing different and just wait to see if the regulators are really going to sort of crack down. And the risk of that, as you know, is that really heavy weight of the GDPR fines. You mentioned that they were high, but how high? I mean, it could be as much as 4% of your worldwide revenue, right? Or tens of millions of dollars. So doing nothing and hoping for the best, not a great option either. Another option is, you could examine whether or not this type of information that your company has is likely to be the result, the focus of some sort of subpoena. But that's not all that comforting either. So I like the thing you just hit on, and I'd like to circle back to that. How would this work? Talk to me, if you would, about encrypting data before it goes to the cloud, because that would seem to me a way to minimize the risk of PII getting revealed if it happens to have to go to other countries because of the manner in which they do business.
Well, and that's a good point. I mean, to be extra safe, I would suggest, number one, as the EU company transferring the data, obviously they're going to do it electronically. So number one, the data should probably be encrypted in transit. But also, once it reaches the data processor, the company in the U.S. who's taking possession of the data, obviously, in vast majority of the time, due to digital transformation and all kinds of neat buzzwords, it's probably going to be stored in the cloud. The idea that before you move it into a third-party cloud, and we're not disparaging third-party clouds. They're making the world work. So it's great, but you need to understand what the security is and what the government or the courts can do to demand access to it. And so what you want to do is take the possibility of the third-party cloud provider take them out of the equation so that, yeah, your data exists up there, but if it's totally encrypted and unreadable, fine. Maybe they give the encrypted copy to the government and the government warns you, you cannot tell these guys that we took this stuff unusable and cannot be used, cannot be accessed, and so forth. So, my thought was this: would the combination of strict data encryption procedures and technologies that at least put the decision on responding to a government order and decrypting data into the owner's hands versus a third party, the combination of that technology, as well as maybe looking at the idea of companies who are regularly taking possession of EU personal information, if they are maybe contracting with a large third party, consulting company or law firm to do proactively put in place privacy impact assessments that the company could hold up to the EU regulatory officers and say, listen, we've gone beyond this point. Number one, we have created or we have purchased technology that gives us more management and control of the EU PI above and beyond the Cloud Act. But also we've had a third-party organization come in and look at, number one, the technology, but also our policies and procedures, and have given us a grade on a privacy impact assessment. Would having those two things in place maybe take the place of the invalidated Privacy Shield or the probably soon-to-be invalidated standard contractual clauses? Would it take the speed bumps away?
Bill, this is an interesting idea because as part of the privacy impact assessment, the company could identify the use of this encryption strategy sort of front and center to show that it cannot be, or the data cannot be accessed traditionally if they are subject to some type of investigation that gives the European regulators some sort of pause. I like this idea.
Yeah, I think that's the basis of their, to put it bluntly, their heartburn over this whole thing. What we're trying to do is to say, okay, Privacy Shield is gone away. SCCs are probably going to go away. And if that's the case, because of the data protection impact assessment requirements in the GDPR, it seems to me that data transfers, like it was referenced in the Facebook case, are going to have to stop. I mean, even not doing anything, I think on the EU side, they're going to be telling those companies that are collecting PI, you cannot transfer anything to the United States, period, because nothing addresses our concerns. And the idea is, besides, SECs that really don't address the actual issue, putting these technologies and impact assessments in place proactively, would that show potentially enough ownership to the EU that the data is being protected at a much higher level?
I think the EU would be hard-pressed to find that there's a genuine risk to that data if it's encrypted before it gets to the ISP. What is interesting to me is how U.S. law enforcement may react to something that is so unreachable, even by way of a subpoena. And I'm thinking about encryption strategies that go over the 256. It's just interesting. It's interesting, but the option that you've laid out with this encryption in advance is a very interesting workaround.
Yeah, it would at least show the companies in the EU who are going to transfer the data, as well as the EU, data protection authorities, that there is a much higher level of protection potentially with these solutions. And, it all comes down to, will the U.S. company fight or at least question a government or court request for data? versus a third-party cloud provider just saying, sure, here it is, and no, we won't tell them. That's probably partly the heartburn, we saw from the Schrems II decision, that, the data owners in the EU will never know if that data was accessed by the United States government or the courts. So I think it's an interesting subject, and I think the idea of having privacy impact assessments preemptively that also takes into account the additional security technology, I think would be interesting to present that to the EU GDPR folks to say, what does this rise to the level of reducing your hesitancy?
Yeah, it's almost a loaded question. How could it not? Short of keeping all of the data within its own jurisdiction, the individual jurisdictions of the EU.
Exactly. I mean, potentially.
And that's not a practical solution.
No, it's not.
Given international commerce.
Yeah, I mean, obviously, data has value. Otherwise, we wouldn't be talking about this. And the European Union is to be commended for going above and beyond the rest of the world in protecting the data from, misuse and all kinds of other stuff. I think we understand what the U.S. government was doing because we've had so many examples of data, the Apple iPhone case and so forth, of potential terrorist data not being accessible, and that was one of the main drivers for the Cloud Act. But it was so far-reaching that it put into question this idea of just standard, industrial data transfers, and we really need to address that. And by the way, I don't want to end the podcast before we mention, number one, Archive 360 does provide a cloud-based information management and archiving system. The difference is it's not in a third-party cloud. It's in the client's own Azure tenancy. So they have complete control of it. But we also provide the ability to do on-premise encryption before transfer to the cloud, where those encryption keys used are kept on-premise locally under the protection of your company itself. So, I mean,
let me ask you something. Let me ask you something about that, Bill. When you say the encryption keys are on site, so in effect, the internet service provider does not have the encryption keys. Is that right?
Exactly. They hold the data, but they hold it in an unusable format that they cannot open or view.
So if the internet service provider had a wayward employee, and I'm thinking a Paige Thompson-like employee, that was responsible for the Capital One.
Yeah, at Amazon. Yeah.
This would protect against that scenario happening because the ISP doesn't have any access to the encrypted data.
Exactly, and that's exactly right on the AWS Capital One thing and case, as well as one of the issues that chief information security officers have had with the cloud in general is, I'm going to move it up to a SaaS cloud. And within the SaaS cloud, third-party SaaS cloud, they're going to encrypt it for me, and therefore it's safe. Well, those encryption keys are stored in the cloud, controlled by the SaaS provider. So, the potential worry is, well, gee, one of the employees in the third-party cloud is going to grab the keys and look at my data. You can argue whether it's even worth enough, to do that. I would suggest, especially law firms, storing data in the SaaS cloud, that those data sets are extremely valuable, and those would become a major target. But even more so, like on the Capital One AWS case, that was, I believe, a privilege escalation case where the person at AWS started a phishing campaign, I think, within Capital One, and I may be wrong on this, but I don't think I am. They basically transitioned from a phishing campaign into basically getting people to give her more and more privilege within the system, privilege escalation.
Right. Earlier, I didn't want it to sound earlier that I meant that she simply had the encryption keys and then, went to town disclosing that information. I think this was a more sophisticated than that, where she recognized certain vulnerabilities in the Capital One system. And
then, the data was not encrypted.
Right. But like you said, data was encrypted. Then that would have presented a sizable challenge for her and any other would-be hacker to reveal it.
Yeah, it would have been a major roadblock. She probably could not have viewed the data. The idea is that if the data is encrypted locally and the key stored locally, you put it up in the cloud. Doesn't matter, if people run ransomware against you or phishing or privilege escalation. If the keys themselves are protected locally, then you're protecting yourselves from all of those kinds of activities. So it really is kind of a straightforward, drop dead easy way to stop these kinds of risks. And based on the topic we're talking about, I think really addresses 70-80% of the GDPR issues with Privacy Shield and SECs.
Yeah, and like we've seen with many of these standards that some people believe are unworkable in total, efforts made to achieve what's called substantial compliance go a long way.
That's a great point. And we've run across this in the U.S. courts as well. If you don't do anything and you should have known that you should have done something, that sends one message to a judge. If you did a lot and really documented what you were trying to do to meet a certain obligation, that also means a lot to the judge. You're not just sitting there, saying, well, we'll see if we get sued, versus doing all the right stuff. And on occasion, yeah, you still might lose out on data leakage or something like that. But doing industry best practices, for example, goes a long way in sending a message to a data protection authority or to the courts that you were trying to be compliant.
I like the idea, Bill, where you couple the impact assessment, encryption of your data locally first before migration to the cloud. I think that has a great 1-2 punch, and I think it does show that substantial compliance. And I think if any companies were reticent to go forward with their cloud initiative, this should be the type of strategy that they employ to get rid of those feelings of uneasiness that a CISO may have.
Well, and that's a great point. And what I just talked about in reference to the local encryption and encryption key storage, I mean, that goes for all companies, not just companies dealing in EU personal information. With ransomware, exploding and cases being encrypted and then let loose on the internet, to basically release the private information. Having local encryption, local key management addresses a lot of the ransomware issues as well. Well, Jim, I think that the great discussion, I think that wraps up this topic and this podcast. If anyone has questions on this, what we talked about today, please send an email mentioning this podcast to info@archive360.com, and we'll get back to you just as soon as possible. You can also check out some of the blogs where we talk about this topic up on the archive360.com/blog site. And, check back with us on a regular basis, because we will be posting blogs on new topics regularly. So thank you all, and thank you, Jim.
Bill, it was good joining you today, and I look forward to speaking with you again.
Thank you for joining us today on the Information Management 360 podcast, brought to you by Archive 360, trusted by organizations worldwide to manage their data in their cloud under their control. To subscribe to our show or to find out how you can address today's challenges in information management, visit archive360.com/podcasts.